any line of conflict to attack and kill innocent civilians at nightclubs and a unity rally. This morning we will tell you about all these events, which demonstrate that Russia's path of non-cooperation flagrantly violated its treaty obligations to cooperate to prevent and punish the financing of terrorism. Ukraine's evidence is detailed, multifaceted, but our case is simple. The ICSFT focuses not on labels, but on acts that states must not fund. The DPR, LPR, and others in Ukraine carried out such acts, which are covered by Articles 2, 1A and B of the Convention. Under Article 2, these acts may not be funded by, quote, any person, which this court has already held would include officials of the Russian government. Yet instead, Russian officials repeatedly gave funds to support acts that Russia was forbidden to fund. By doing nothing to stop these assets, Russia utterly defaulted on its obligations to obey this solemn treaty. Article 18 of the ICSFT requires states to cooperate in the prevention of offenses set forth in Article 2, that is, prohibited acts of terrorism financing. As Article 18 specifies, that cooperation means taking all practicable measures to prevent and counter preparations in their respective territories for the commission of terrorism financing offenses within or outside their territories. The treaty's twin objectives are suppression and prevention. Most of the convention is devoted to suppression of terrorism financing through investigation, prosecution, and other law enforcement measures. But only Article 18 expressly addresses the proactive measures states must take to prevent and counter preparations in their respective territories for commission of terrorist offenses wherever they occur. If a measure is practicable and could prevent the commission of an Article 2 offense, the state is required by the treaty to take that measure. Article 8 further provides that states shall take appropriate measures to identify, detect, and freeze or seize funds used for terrorism financing. Article 9 concerns the investigation of alleged Article 2 offenses and clearly mandates that upon receiving information that a person who may be in its territory is alleged to have committed a terrorism financing act, the state must investigate. Article 10 similarly concerns prosecution or extradition. If the alleged offender is present on the state's territory, it must either extradite the alleged offender or submit the case without undue delay for purposes of prosecution. Finally, Article 12 forbids half-hearted cooperation. Instead, states parties must afford one another the greatest measure of assistance in connection with criminal investigations or criminal or extradition proceedings in respect of the offenses set forth in Article 2, including assistance in obtaining evidence in their possession necessary for the proceedings. Read together, these provisions require that the state do something. It requires a good faith structure for genuine cooperation to suppress terrorism financing and offense. But with respect to Ukraine, Russia did nothing. It has displayed instead complete non-cooperation and has refused to take even the most minimal measure to prevent terrorism financing. Russia has ignored Ukraine's most basic requests for cooperation and investigation, even as weapons flow uncontrolled across the border. Our evidence shows the reason. Russia's own officials were providing funds to groups committing terrorist acts in Ukraine. And now, Russia's brazen non-cooperation continues in this great hall of justice, where it continues to make a mockery of its legal commitments. At every turn, Russia has twisted the treaty's text to invent limitations on its obligations, and to impose burdens on Ukraine that appear nowhere in the treaty's text. Ukraine's written pleadings address Russia's arguments in great detail, but let me just highlight two examples, Articles 18 and 9. On its face, Article 18 requires Russia to cooperate in the prevention of prohibited offenses by taking all practicable measures to prevent and counter preparations for the commission of those offenses. Yet Russia reads this expansive language as obliging it only to establish a regulatory framework for the prevention of the financing of terrorism. So Russia would shrink its obligation so that it must take no practicable measure, apart from adopting a law on the books that its officials then ignore. So long as Russia passes a paper law saying that terrorism financing is illegal, it need actually do nothing to stop anyone from financing terrorism. It need not police its border to prevent the supply of weapons for use in terrorist acts. It need not even stop its own officials from brazenly financing terrorism. Article 9 similarly requires Russia to investigate if it receives information that a person who has committed or who is alleged to have committed a covered offense may be present in its territory. Again, Russia would shrink this treaty obligation to nothing. Russia insists that before it has any obligation to investigate an alleged offense, the occurrence of such offense must be, quote, conclusively proven with the requisite specific intent. In short, Russia need not investigate a potential crime unless the perpetrator's mental state has already been proven in advance. Consider how absurd this reading is. A state need not investigate a possible crime until after the crime is fully proven. In the first sentence of Article 9, Russia would rewrite the words to substitute for the word alleged the words conclusively proven. But what kind of legal system requires interstate cooperation to investigate possible crimes only after the crimes have been conclusively proven? No criminal justice system in the world works like that. Madam President, members of the court, the rest of Russia's legal analysis just repeats this false claim that Russia obeyed its treaty obligations to cooperate. In the world works like that. Madam President, members of the court, the rest of Russia's legal analysis just repeats this false claim that Russia obeyed its treaty obligations to cooperate. They say, how? By doing nothing, because the Convention's obligations, in their eyes, require no meaningful action. In short, this court is asked by Russia to absolve it of responsibility by gutting a convention developed to protect civilians and human rights, and by so asking Russia only underscores its contempt for the rule of law, human rights, the Ukrainian people, and this court. Russia's rejoinder continues its non-cooperation by claiming for the first time that Ukraine has unclean hands, thus nullifying Russia's responsibility for its own violations of the ICSFT. This frivolous argument need not detain you long, for as this court recently noted in certain Iranian assets, you have never held that the clean hands doctrine was part of customary international law or constituted a general principle of law. As a defense on the merits, the court has always treated the invocation of unclean hands with the utmost caution. This case shows why this court wisely exercises such caution. Russia's factual narrative in support of this defense is a work of propaganda. It offers many citations, but they are to state-sponsored Russian media, and even to their own preliminary objections in another case, of which we'll surely hear more on Thursday. then based on such dubious sources, Russia continues its historic big lie that Ukraine, not Russia, is to blame for harming its own citizens. But given the total absence of evidence submitted by Russia, this court need only ask, who did UN human rights monitors find was responsible for a reign of intimidation and terror? Who destroyed MH17, a civilian aircraft? Who did UN officials say knowingly targeted the civilian population of Mariupol? A simple answer, not Ukraine. Russia falsely equates alleged coal purchases by Ukrainian officials in their own territory with Russian officials supplying deadly weapons to terrorist groups they know target innocent civilians in another independent nation. This offensive comparison only underscores that Russia intends its unclean hands argument as a distraction, not as a meaningful defense to any of Ukraine's claims. Madam President, members of the court, Ukraine has presented overwhelming, undisputed evidence that vast sums of money, weapons, and other equipment have been transferred from Russia to Ukraine. This includes open and active fundraising in Russia for illegal armed groups operating in Ukraine. As my colleague Ms. Cheek will detail shortly, Russian billionaires and Russian coordination centers have openly provided monetary assistance to the DPR and LPR, and even Russian lawmakers have actively and publicly solicited donations to the DPR and the LPR. In response, Russia has done nothing. Ukraine has presented equally ample evidence regarding the transfer of weapons from Russia to these illegal armed groups. Because Russia cannot dispute these facts, it makes instead the implausible claim that a convention to stop terrorism financing was never intended to restrict the supply of weapons to terrorists. To ensure the broadest cooperation to prevent and suppress the commission of terrorism financing, Article 1 of the Convention broadly defines the term funds to mean assets of every kind, whether tangible or intangible, movable or immovable, however acquired. Yet here too, Russia asks you to justify its open non-cooperation. How? By stripping these words from the treaty. On its face, this text leaves no doubt. The treaty's ban on terrorism financing covers assets of every kind, including a Buk anti-aircraft system, multiple launch rocket systems, limpet mines. The ordinary meaning of assets of every kind, tangible or intangible, is weapons, equipment, other forms of property, as much as the rubles or dollars used to buy such weapons, equipment, and property. All of these are tangible assets, assets of every kind, and therefore funds of the kind Russian officials may not supply if they are serious about seeking to suppress the financing of terrorism. In Russia's rejoinder, it grudgingly concedes that the term assets may convene the meaning of the property of a person in the broad sense as indicated by Ukraine. So the parties agree on the key point. The ordinary meaning of assets, and here funds, covers every form of property, including weapons. But Russia tries to escape the ordinary meaning of assets by narrowing it to conform to their own dictionary's definition of funds. This is backwards treaty interpretation, a task for which dictionary definitions are simply beside the point. Recall Article 31(4) of the Vienna Convention on the Law of Treaties. A special meaning shall be given to a term if it is established that the parties so intended. Article 1 of the ICSFT included a set of definitions for the purposes of this convention, including, as we saw, the treaty's own special meaning or definition of funds as covering assets of every kind. The special meaning of funds is assets of every kind, not some definition found in whatever dictionary Russia's lawyers might find. To impose generic dictionary definitions on interpretations of particular treaties, which choose their terms carefully, would upend treaty making by denying drafters the option of adopting specialized definitions that are tailored to meet the particular purposes of a particular treaty. Equally backward is Russia's reliance on the word financing in the treaty's name. That term is prominently nowhere found in the treaty's text. Treaty titles are not operative provisions. By using only the word funds, the text gives that term special meaning, assets of every kind, which defines the breadth and forms of financing the treaty is designed to suppress. Madam President, members of the court, many nations use the term financing of terrorism as shorthand to cover the many variegated forms of terrorism support. For just one example, look at the Russian Supreme Court. Its own reading, the financing of terrorism along with the rendering of financial services, should be understood as a provision or collection not only of money, cash or non-cash, but also material assets, for example, items of uniforms, equipment, means of communication, medicines, residential or non-residential premises, vehicles. So Russia's artificial attempt to narrow the interpretation of funds to monetary assets would offend its own national law as construed by its own Supreme Court. Yet Russia repeats the same flawed tactic that it tried and this court rejected earlier in these proceedings. Russia tried to convince this court that the term any person in Article 2 must mean some persons. This court correctly decided any means any. Similarly, in Article 1, the term every means every. When the treaty refers to assets of every kind, it cannot mean, as Russia argues, only assets of some kind, the monetary kind. Russia's interpretation also violates this court's directive that treaty clauses must be interpreted to avoid rendering them superfluous. The treaty's clarification that an asset may be movable or immovable only makes sense when the term is given its ordinary meaning, assets of every kind, meaning property. Because the treaty prohibits providing an immovable asset like a warehouse to a terrorist to be used as a hideout or weapons depot. But if, as Russia claims, assets of every kind were limited to money, to what then would the term immovable assets refer? Money moves. There's no such thing as immovable money. Russia's reading of funds as monetary assets would make the treaty's mention of movable or immovable assets superfluous. Russia also misreads the second part of the treaty definition of funds. After defining that term to include assets of every kind, it adds, and legal documents or instruments in any form evidencing title to or interest in such assets, listing examples of such documents or instruments. Russia incorrectly calls this list the exclusive and specific categories of assets covered by the ICSFT, claiming that nothing else is covered. Plainly, this is wrong. The definition does not exhaustively describe whatever constitutes assets. It only lists documents or instruments that evidence title to such assets. But on its face, the convention bars providing terrorists of assets of every kind, not just those assets for which someone can prove title by producing a piece of paper. So once again, Russia asks you to ignore the plain terms of the treaty to shrink its scope. Most obviously, Russia's interpretation defies the broad object and purpose of the ICSFT, whose obvious goal was to deny groups any and all resources necessary to commit terrorist acts. Money on its own cannot be used to commit terrorist acts. The international community wanted to prevent terrorists from receiving money because that money can be exchanged for goods that can be used to commit terrorist acts, such as explosives, arms, and equipment. What sense would it make to forbid providing money to terrorists, but allowing the same terrorists to receive directly goods, weapons, and arms that the same money would buy. To accept Russia's attempt to carve this gaping loophole into the treaty would gut the treaty and render it meaningless. And finally, Madam President, the travaux preparatoires confirm assets of every kind mean just what it says, all forms of property, including weapons. From the beginning, the treaty's drafters focused not just on financial and monetary assets, but weapons as well. This early draft of the convention defined the act prohibited by Article 2 as, quote, financing. The substantive offense of financing encompassed financial and non-financial assets. And draft Article 1 defined financing broadly to include not just funds, but assets or other property. At the time, the term funds was defined narrowly to cover any type of financial resource, including cash or currency of any state. But non-financial assets were covered by the term assets or other property. The negotiators debated this wording. No one suggested shrinking the scope of the treaty to address only financial resources. No one ever proposed dropping all non-financial assets from the treaty. Instead, the debate concerned whether to cover just financial resources and weapons or financial resources, weapons, and other forms of property. And as this summary of the negotiations explained, suggestions were made to delete the phrase or other property as superfluous. Some argued in favor of deletion of the word assets. Others preferred retaining both assets. Some preferred interpreting property as covering only arms, explosives, and similar goods. So, as this reflects, there was a proposal to narrow the type of non-financial assets covered. But none of the proposals would have eliminated weapons from the coverage of the treaty. Given this history, Russia's rejoinder is wildly misleading when it claims that the issues of weapons was, in their words, quote, not discussed at all when the convention was negotiated. What this excerpt shows is that weapons, arms, and explosives were openly discussed when the convention was negotiated, and everyone agreed that the convention barred the provision of weapons to terrorists. Ultimately, the states parties resolved the wording debate by taking the concept of financing out of the text and replacing it with a broader definition of funds, defined as assets of every kind. The drafters gave the term funds the broader special meaning given to the definition of property in the Narcotics Convention, assets of every kind. This outcome thus made any separate reference to property, quote, redundant, since it was already envisaged in the concept of funds as defined in Article 1. The drafters adopted a proposal that the term property be deleted wherever it appears in conjunction with funds, since funds was now intended to refer to all property. In short, the travaux clarified that the final version of the treaty omitted the word property because the umbrella term was now funds, assets of every kind, which plainly includes non-financial forms of property, including weapons. This consensus was confirmed after the convention was finalized during the ratification processes in many countries. In the United States, a senior senator asked, in Article 1, does the term funds include non-financial assets such as personal or real property? That senator was named Joe Biden. The State Department responded, yes. All delegations understood the definition to include property. So leading commentators as participated in the negotiations confirmed this view. Marja Leto, who led Finland's delegation, explained that the expansive definition of funds covers material assistance. Roberto Laval, a Guatemalan diplomat who served on the 6th Committee, agreed. The deliberately wide definition swept in such, quote, material assistance as the direct provision of weapons. So in the end, every tool of treaty interpretation points to the same result. By its terms, the convention encompasses assets of every kind, weapons, are one kind of asset. The treaty drafters well understood and discussed that the convention covers all forms of property, not just financial assets. And after the treaty was finalized, states and commentators universally reaffirmed this breadth of coverage. Yet against this evidence, Russia asks you to read an absurd exclusion. They would have you rewrite the phrase assets of every kind to mean assets of every kind except dangerous weapons. This outrageous misreading would create a gigantic loophole through which recalcitrant states could entirely flout their legal duties. While state officials looked the other way and did nothing, private parties could send weapons to Al-Qaeda. A treaty partner could pretend to be suppressing the financing of terrorism, even while allowing or assisting supporters of terrorism to deliver unlawfully the very lethal weapons used to carry out terrorist acts. And this is exactly what Russia is doing here. Russian officials and private supporters are delivering lethal bombs, shells, and missiles directly to those terrorizing the civilian population of a peaceful neighboring country and pretending that they are obeying this convention. Madam President, members of the court, this is not a good faith interpretation of the treaty. It cannot be the law. This misreading violates the convention's ordinary meaning and object and purpose. It's a brazen attempt to escape the solemn commitments Russia made when it ratified the treaty 21 years ago. It would justify Russia's continuing refusal to cooperate with Ukraine in suppressing the financing of terrorism. And adopting their reading would reward and reinforce Russia in its naked contempt for the rule of law and human rights of Ukrainian citizens, which we are all witnessing every day. Madam President, that concludes my presentation. I now ask you to call Professor Tuvinen to the podium.
I thank Professor Coe, and I now give the floor to Professor Jean-Marc Tuvinin. You have the floor, Professor.
Merci, Madame la...
Thank you, Madam President. Madam President, distinguished members of the court, it's always a tremendous honor to speak before you, and today thinking particularly of the judges who have departed and before whom I had the pleasure of pleading in the past. The applicant has entrusted me with the task of shedding light for you on the scope of Article 2, Paragraph 1 of the International Convention on the Suppression of the Financing of Terrorism. I'd like to begin by showing the text on the screen. For your comfort, you will also find it in tab 2 of your file. I'll not read it out. Ukraine contends and demonstrates that persons did commit unlawful acts within the meaning of the chapeau of Article 2, Paragraph 1. In other words, offences financing the acts that come under subparagraphs A and B of that same paragraph. However, the matter before you is not the criminal accusation of a person or a legal entity. You have before you a dispute between Ukraine and Russia because of the total, I would even say culpable, passivity of Russia in the face of massive flows of financing for terrorist acts coming not just from its own territory but also from its own state officials. This is the case that Ukraine is making before you. For its defense, Russia puts to you a totally erroneous interpretation of Article 2 of the Convention before persisting in distorting facts. Maître David Zients will, after me, give you the interpretation of Article 2, Paragraph 1, subparagraph A. I shall deal with the remainder of Article 2, Paragraph 1, and to begin with, I will refer to subparagraph B, and then, after that, go to the heading of Article 2, Paragraph 1. I shall conclude by recalling the terrorist acts committed by the armed gangs of Donetsk and Luhansk in the spring and in the summer of 2014. So let us begin with Article 2, Paragraph 1, Subparagraph B. It refers to all acts that are not already covered by Subparagraph A if they show two cumulative features. First of all, any act intended to cause death or serious bodily injury to a civilian or to any other person not taking an active part in the hostilities in a situation of armed conflict. Secondly, the same acts are covered if, when the purpose of such act by nature or context is to intimidate a population or to compel a government or an international organization to do or to abstain from doing any act. Russia claims that an act fits in with this description if and only if it is proved that there is a twofold intention on the part of the perpetrator: intention to cause death or bodily injury to civilians, and the intention to do so with the sole or main purpose of intimidating a population or compelling a government. Ukraine, a contrario, contends that it is enough for the acts to be of a certain nature or to be committed in a certain context to fall under subparagraph B, without there being any need to prove in any other way the subjective intention of the perpetrator of those acts. Therein lies our dispute. Madam President, the Court can already note that the parties agree that the first feature of the act described in subparagraph B, which is intended to cause death or serious bodily injury to civilians, is present when a person or a group of persons carries out a lethal action deliberately targeting civilians, including in a situation of armed conflict. Ukraine has demonstrated and will demonstrate again today that the terrorist actions to which it was subjected are precisely murderous deeds that deliberately targeted civilians. But Ukraine also contends that in order to determine what is an act designed to cause death or serious bodily injury of a civilian within the meaning of subparagraph B, the subjective intention of the author, the perpetrator, does not need to be established. Subparagraph B is purely descriptive. It gives you a category of facts. The only perpetrator targeted by Article 2 under the offence that is established is the person providing the funding. It is that person committing the offence created by the Convention, not the person perpetrating the acts financed by the funding. So the act intended to cause death or injury is described objectively by the fact that by its nature, and not because a perpetrator entertains certain ideas, the result is simply to cause death or serious bodily injury to civilians. The defendant promotes another line that's already rebutted at length in Ukraine's written submissions. So with all due respect, I would suggest to the court that you read paragraphs 155 to 161 of the reply, and I shall remain concise on this point. On the one hand, Russia confuses the acts committed with the intent to, mentioned, for instance, in Article 2, Paragraph 1, subparagraphs A and B of the Convention for the Suppression of Terrorist Bombing, or again, in Article 2 of the Convention on Genocide, or again, in the chapeau of Article 2, Paragraph 1 of the Third Convention. You can see the text on the screen, and they expressly refer to the intention of a perpetrator of an act. And what is more, the acts intended to, which are covered by subparagraph B, that is the subject of my presentation here. There should be no confusion here. These are two formulations that are intentionally separate. The first refers to a perpetrator's intention to carry out a criminalized act, and the second describes objectively an act with regard to its destination, in other words, as regards the end result, without necessarily criminalizing it In other words, without taking a look at the criminal intent of its perpetrator. Russia incorrectly is reasoning as if the convention were criminalizing the acts intended to cause death or bodily injury to civilians that it prescribes the financing of. This is not the case. So it is wrong to interpret from the angle of criminal law, subparagraph B, requiring that the intent of the perpetrator of the acts described be established. Furthermore, Madam President, as regards Russia, at least as it stands here before you, because back home its interpretation is quite different, the Italian Court of Cassation does not commit the error that Russia would have you make. It does not take account of the intention of the perpetrator of the act covered by subparagraph B, but only the nature of that act. In Italy versus Abdelaziz et al. From 2007, its ruling was crystal clear, and I quote,
Against a military objective must also be regarded as terrorism if the particular circumstances show beyond any doubt that serious harm to the life and integrity of the civilian population are inevitable, creating fear and panic among the local people. A simple example is an attack using explosives against a military vehicle in a crowded market.
End of citation. Your court will also note the ruling of the Supreme Court of Denmark from 2009 in the case Fighters and Lovers, where it was a question of interpreting the Danish law on implementation of Article 2, Paragraph 1, subparagraph B of the Convention. The Supreme Court ruled that the FARC, the Colombian Revolutionary Armed Forces, that had received funding for which those providing it were prosecuted, were deemed to have committed acts referred to under Article 2, Paragraph 1, subparagraph B, inter alia, because they had used inaccurate mortar shells in civilian areas where civilians died from their injuries. It did not seek in any other way the subjective intention of those who had fired the shells. Madam President, distinguished members of the Court, there is a second feature that an act must have in order to be covered by subparagraph B. Its purpose must be to intimidate a population or to compel a government or international organization to do or abstain from doing an act. How do we know that an act has such a purpose? The text tells us. It is by taking account of its nature or its context. That does not mean that the purpose of the act is not a relevant element. It is. The Court furthermore suggested this in its decision on provisional measures, and in this respect, the lengthy developments by Russia under paragraphs 236 et sec of its counter-memorial state the obvious, if you don't mind my saying. But this means that, as regards subparagraph B, determination of what is the purpose of an act is done in the light of the nature of the act or the context in which the act is committed. That is precisely what the text of Article 2, Paragraph 1, subparagraph B says. The words are carefully chosen. No reference is made to the intentions of the perpetrators, and let me recall once again that they are not criminalized by the Convention, contrary to the Convention on Genocide, to which Russia vainly clings, and contrary to other texts, such as the chapeau of Article 2, Paragraph 1 of the Convention of the CERD. What is more, whether I need to verify this in the light of travaux préparatoires, we'd see that the drafters of the Convention have expressly, intentionally excluded this intention. During the discussions within the working group of the 6th Committee of the General Assembly, Costa Rica and Mexico proposed that subparagraph B be rewritten in the following fashion. I quote, "Acts intended to cause death or serious bodily harm to a person when such acts are committed with the intent to provoke terror in the population or to compel a legal person, an international organization, or a state to commit or refrain from committing an act." End of quotation. This amendment, which was on its own, did not succeed. The chair of the working group of the 6th Committee gave an explanation for this in its report, and I quote once again, "A proposal was made to delete the phrase by its nature or context. Some opposed this deletion because it would suggest that the offence required proof of the perpetrator's subjective state of mind." End of quotation. So it was dismissed. The Russian argument is thus unsupported. But, Madam President, distinguished members of the Court, Russia also persists in arguing that the purpose of the act described in subparagraph B must be solely or mainly or specifically to intimidate the population or to compel a government. Or it quite simply says intimidate the population. There are 3 answers to be given here. Each is critical. First of all, and it is really quite striking, Russia claims that the interpretation of Article 2, Paragraph 1, Paragraph B, and let me remind you here that it concerns not just the acts whose purpose is to terrorize the civilian population, but also those which serve to compel the government, in the light of other texts, inter alia additional protocols 1 and 2, which under terrorism state that its acts, the purpose of which is to strike terror in the civilian population, excluding any act whose purpose is to compel the government. The scope, the substance of the texts is manifestly very different. So interpreting the first in the light of the others would be totally disjointed. Secondly, for the Russian argument to prevail, it would be necessary to rewrite the text because the latter does not say when the purpose of such an act, by its nature or context, is to intimidate a population or compel a government. Contrary, for example, to Article 13, Paragraph 2 of the Additional Protocol 2, or, again, Paragraph 84 of the Rules Concerning Application of International Humanitarian Law by the Armed Forces of the Russian Federation, which was published on the 8th of August 2001 by the Russian Ministry of Defense, which forbids acts of violence whose main purpose is to strike terror into the civilian population. But Russia cannot rewrite the text. In the convention discussed here, the notion of main purpose is not to be found, neither explicitly nor implicitly. Thirdly, Russia would once again have you forget that the sole purpose of the convention is to prevent and suppress the financing of terrorism. It would have no effet utile in terms of preventing the financing of terrorism if it were necessary before a state can demand that another state cooperates in order to bring an end to the financing of acts that cause death and injury to civilians and whose purpose is to terrorize the population or to compel a government, to prove that that purpose is main or sole. Whatever Russia says, Madam President, distinguished members of the Court, within the meaning of the Convention, an attack that deliberately targets an area known to be full of civilians, or an indiscriminate attack, inter alia using inaccurate weaponry with no capacity of discernment, fired over an area in which there are civilians and military personnel, is an act whose purpose, by its nature or context, is to terrorize the population, independent of the fact that there might be other targets, for instance, military ones. Let me add that such acts also have the purpose by their nature or context of compelling the government. But Russia, never short of subterfuge, claims in its counter-memorial that the Convention would not apply in a situation of armed conflict when the purpose of the financed acts is to compel the government. It claims that this is because the law on armed conflict does not qualify as terrorist acts whose purpose is to compel the government, and that the Convention should be interpreted in accordance with the law on armed conflict. Consequently, according to Russia, in a situation of armed conflict, any compelling of the government would be covered by subparagraph B only if, and I quote Russia, if it is related to something beyond the overall goal of armed conflict as such. End of quotation. Something beyond? The court will lend no credibility to this argument that's been pulled out of thin air. Madam President, because of these latter comments, I will have to go further into the role that Russia would have the law on armed conflict play. Article 2, paragraph 1, subgraph B. Its argument is that that cannot qualify as an offence an act which, what is more, was not considered as terrorist by international humanitarian law. In other words, what is, according to Russia, lawful in humanitarian international law cannot be unlawful under the Convention on Financing of Terrorism. The court will doubtless note that this is a purely academic debate because none of the acts whose financing has been incriminated by Ukraine is compatible with humanitarian international law. Nevertheless, the Russian argument is legally flawed. First, international humanitarian law authorizes nothing of any relevance here. It only proscribes. This does not mean that what is not forbidden under international humanitarian law is deemed authorized by international law. On the contrary, what is neither proscribed nor permitted under international humanitarian law may still be proscribed by other branches of international law. Secondly, contrary to international humanitarian law and contrary to Russia's sustained belief, the Convention is not intended to create terrorism offences, neither in times of armed conflict nor in times of peace. I have already made the point. It is neither its purpose nor what it does. It simply criminalizes transnational financing of certain acts that it describes. In contrast, the law on armed conflict is not concerned with the transnational financing of terrorism. So there is no reason to limit arbitrarily the scope of the Convention by referring to international humanitarian law, which cannot be the lex specialis, because by definition there can be no normative conflict between the two sets of standards. Moreover, if one were to invoke the notion of lex specialis, quod non, this would clearly lie with the Convention, because it alone deals with the financing of certain acts. What is more, without any doubt, the Convention is lex posterior.
Madam President, distinguished members of the Court, I mentioned that what is considered as an offence by the Convention is the funding of certain acts. Allow me now to address the chapeau of Article 2, paragraph 1. Ukraine contends that it follows from this text that an offence is established when the financier provides funds to a group known to commit acts for which funding is prohibited. So, a well-known terrorist group can use funds made available in different ways, for example, for propaganda campaigns or to buy food supplies, military uniforms, transport vehicles, or even weapons. But monetary funds are fungible. I will talk about weapons in a moment. Therefore, the person providing such funds to a group known to carry out acts whose financing is proscribed is necessarily aware, due to their fungibility, and unless the use of such funds requires that proof of specific purchases be provided, knows that the monetary funds provided will be used or are to be used in full or in part in order to carry out acts for which providing funding is prohibited. Even so, the text states that the funds are to be used in full or in part, confirm that it is not required to demonstrate the precise attribution of those funds to specific acts under paragraph B. In fact, terrorists will probably never disclose their plans in advance. So if the financier were to be required to know beforehand what precise actions the terrorist groups intend to carry out in order to characterize the funding as an offense, it would probably never be constituted. Article 2 of paragraph 3 reinforces this interpretation because it establishes that, and I quote, for an act to constitute an offence set forth in paragraph 1, it shall not be necessary that the funds were actually used to carry out an offence referred to in paragraph 1, paragraphs A or B. End of quote. Furthermore, to demand a verification of the exact use of funds provided, which in practice is generally impossible, would be incompatible with the object and purpose of the Convention, which is to promote interstate cooperation to eliminate financing of transnational terrorism. It would be tantamount to interpreting Article 2, Paragraph 1 in such a way that it would make it meaningless, which would be contrary to the principle of meaningful formulated by the Court. And it is perfectly obvious that when the items provided to the group are weapons, the knowledge of the financier as to the utilization, their utilization, that is to say, to commit acts for which funding is prohibited, shall be established if the group is known to commit such acts. And, in fact, the best-informed commentators, some of whom were directly involved in the Convention negotiations, confirm this interpretation of Ukraine. The ambassador Maria Leto wrote,
has notoriously committed terrorist act would meet the requirements of paragraph 1. Fin de citation.
End of quote. She recounts that during the negotiations, it had been recurrently mentioned that violation of Article 2, Paragraph 1 is constituted in the case of
an organization that carries out multiple activities of a political and social as well as military nature, and where it may not be possible for the financier to make a distinction between the different possible end uses. Fin de citation.
End of quote. Along the same lines, Roberto Laval explains in his study on the Convention that I quote,
of a primary offense under the Convention, it is sufficient to prove that the recipient or recipients, actual or intended, of the funds are terrorists, that that person was aware of this, and that accordingly he or she had to know that the funds would probably be used or could be used to commit an offense or offenses covered by one of the treaties listed in the annex to the Financing Convention or falling within the residual category.
End of quote. To be thorough, Madam President, I would like to point out that Russia continues to hold on to the argument according to which it is not enough that funds were provided to a terrorist group by a person who did not know the details of how they would be used, or only knew that there was a risk that the funds would be attributed to a certain kind of utilization. But Ukraine does not claim that ignorance as to the destination of the funds or the mere awareness of a probability that they will be used in a certain manner is the relevant criterion. Ukraine is of the opinion that Article 2, Paragraph 1 requires knowledge of the destination of the funds, but asserts that this knowledge can be deduced from objective factual circumstances and not simply by carrying out a detailed analysis of the subjective intent of the financier. In other words, if the financier knows that the beneficiary commits terrorist attacks, the knowledge criterion is met. Even so, Russia's quarrel with Ukraine on this point is not applicable because it acknowledges that financing a group known to commit terrorist attacks is an offense. Indeed, in its counter-memorial on the screen, Russia wrote the following in this regard.
It would be no defense for the financier to say that he/she intended the funds to contribute to the non-terrorist activities of the relevant group, or that he/she could not know whether the funds are to be used to commit a terrorist act or for some other purposes. Fin de citation.
End of quote. Russia appears to regret having had the honesty to concede this in its rejoinder. It now claims that only groups specifically identified as terrorists by the United Nations Security Council could be considered as groups known to commit acts described in subparagraphs A and B of Article 2, Paragraph 1. But obviously, knowledge that a person can have that a group is committing the acts described in subparagraphs A and B is independent of its identification by the Security Council, which is probably not the only source of information in this respect. The question is not, therefore, whether the Security Council has included armed groups of Donetsk and Luhansk in their list of terrorist groups. The question is whether the people financing them could have possibly been unaware. Therefore, they must have known, based on objective factual circumstances, that these groups committed acts covered by Article 2, subparagraphs A and B. This was clearly the case of the self-proclaimed Popular Republic of Donetsk and Luhansk in the spring and summer of 2014. Madam President, I have 10 minutes left. I leave it to you to decide whether you wish to take a break at this point.
Go ahead and finish up, and then we'll take a break after that. Please go ahead.
Merci, Madame la Présidente.
Thank you, Madam President. The acts of intimidation and terror committed by armed groups from Donetsk and Luhansk are documented. It was public knowledge. In spring and summer of 2014, nobody could have possibly claimed not to know their nature or context. In its successive reports in 2014, the United Nations High Commissioner for Human Rights underlined that numerous acts aimed at killing and seriously injuring civilians were regularly committed in the east of Ukraine. In its report of the 15th of November 2014, it says,
an increasing number of human rights abuses, such as abductions, harassment, and unlawful detentions, in particular of journalists. This is leading to a breakdown in law and order and a climate of intimidation and harassment.
End of quote. The same report emphasizes
groups have increasingly committed human rights abuses, including abductions, torture, ill treatment, unlawful detentions and killings.
End of quote. In a report of June 2014, the High Commission for Human Rights was shocked at
acts of ill treatment and torture and killings by armed groups are now affecting the broader population of the two eastern regions, which are now marked by an atmosphere of intimidation and consequent fear.
End of quote. In another report dated July 2014, the High Commissioner deplored the fact that separatist groups of the Donbass, and I quote,
of Ukrainian territory and inflicted on the population a reign of intimidation and terror to maintain their position of control. Fancy.
End of quote. In its report of 19th of September 2014, the Human Rights Council and the UN High Commissioner for HR observed, and I will say it in French, quote, the reign of fear and intimidation by the armed groups has been well documented in the reports of the Human Rights Monitoring Mission in Ukraine, end of quote. Russia did not contest these facts in its counter-memorial. And if more proof were required, all we need to do is recall how appalled the High Commissioner of Human Rights, Navi Pillai, was in July 2014. In fact, he is now an ad hoc judge in a pending case before this court. In October 2014, Ivan Simonovic, Deputy UN Secretary General for Human Rights, indicated the Security Council that the situation in the Donbass...
Fear and terror in areas under control of the armed groups. Fin de citation.
End of quote. There is no doubt that the aim of creating a state of terror by the so-called DPR and LPR was to force Ukrainians to accept that they had taken total control over Donbass. Apart from shelling and civilian areas, targeted attacks were perpetrated on specific individuals, which was very worrying for Ukrainians who were considered by the separatists as being pro-Ukrainian or pro-Maidan. They could be politicians, journalists, activists, or persons suspected of supporting Ukrainian authorities. In its memorial, the court will find, amongst other things, accounts of the terrible assassination of Mr. Rybak, municipal councillor of Horlivka, who dared to wave the Ukrainian flag on the town hall of his city on the 17th of April 2014, and assassination attacks of political leaders, the murder of a priest, multiple abductions and acts of torture. In other words, systematic persecution of opponents or persons considered as such. Russia pretends, or rather pretends not to believe, that such atrocities were committed with the aim of terrorizing the population or to compel the Ukrainian government. The counter-memorial also states a very strange theory, according to which, even though the Ukrainian population was terrorized by repeated violence by armed groups, it did not necessarily imply that these acts were aimed, due to their nature or context, at spreading terror. In fact, it was done inadvertently. The court will decide if this was the case. So what the Deputy Secretary General for Political Affairs, Mr. Feldman, denounced in front of the Security Council on 29th of April 2014 was, as I say, increasing reports of torture, kidnapping and violent acts and clashes were merely indiscriminate or senseless acts of violence or even heinous crimes. Is Russia claiming that the separatists suffered from dementia? Well, as soon as this claim is made, it collapses under the weight of its sheer inanity. In its rejoinder, Russia believes that it can convince us of the contrary by relying mainly on two cases. First, Russia attacks the murder of the municipal councillor of Horlivka, Vladimir Rybak, that had horrified even the members of the Security Council during its meeting of the 29th of April 2014. Russia claims that it has not been established that this was a political assassination and that the DPR was involved. But as I noted in my introduction, we're not conducting criminal proceedings here against the perpetrators. What matters is that this act was denounced by UN organs and public reports as a political crime committed by separatist rebels. It is therefore a known fact. Russia then goes on to attack the murders of Valery Salo and other pro-Ukrainian farmers. It alleges that there was no proof of these murders because the Human Rights Commission published the facts that were reported to it without actually verifying their veracity, and therefore nothing can prove that this was not just a heinous crime or a personal vendetta. I will simply note that in its report of 15th of June 2014, the High Commissioner for Human Rights mentions in the first paragraph itself
findings of the United Nations Human Rights Monitoring Mission in Ukraine covering the period 7 May, 7 June 2014.
Amongst these findings, Mr. Salo's murder was mentioned because he was a pro-Maidan activist. This court sets great store by what UN organs write, and you will note that when the Human Rights Commission has a doubt in a fact, he indicates that it is alleged, which is not the case here. Whatever be the case, once again, the only real question here is to establish whether this incident reported by the High Commissioner of the United Nations and also by numerous media outlets makes it a known fact that separatist groups of the Donbass commit acts that, due to their nature and context, aimed at spreading terror in the population and compelling the government. The answer is, without the slightest doubt, in the affirmative. This brings me to conclude that, Madam President, distinguished members of the Court, in the spring and summer of 2014, no one could possibly ignore what the Ukrainian population was going through. DPR and LPR armed groups were known to be the perpetrators of numerous increasingly violent acts, falling manifestly under Article 2, paragraphs A or B of the Convention. In particular, acts aimed at killing or seriously injuring civilians. Their purpose, as observed by UN organs, was to take total or partial control over Ukrainian territory by dissuading through terror, by dissuading the population from resisting, and we know how much this population can resist. And this is why there were an increasing number of acts aimed at terrorizing them and to compel the government. It was public knowledge. No one could possibly ignore their acts of intimidation and political terror, and nobody providing funds to these groups could have ignored that they were going to be used for such acts. Madam President, this concludes my presentation in a hurry to take a break. And after the break, I urge you to call upon Mr. David Swans for his pleading. Thank you.
Mr. Tuvunen, before I invite the next speaker to take the floor, the Court will observe a coffee break of 15 minutes. Sitting is suspended.